Start.
Welcome everyone. I am Ms. M. Vaidhehi, Assistant Professor, Department of Business Administration with CA, Vellalar College Foreman, Autonomous Zero. And today we are going to see about the essential elements of a valid contract. So before going into the essential elements of a valid contract, let us know about what is meant by contract. So contract is, according to section 2 of the Indian Contract Act 1972, contract is defined as an agreement enforceable by law. So what they are saying here is a contract is an agreement which should be enforced by law. If it is not enforced by law, we are not considering it as a contract. And next, we can see about the agreement, because we see that contract is an agreement enforceable by law. So we have to know what is meant by agreement. So an agreement, every promise or every set of promise forming consideration for each other. So your agreement is defined as every promise or every set of promise. That is, both the parties will make a promise. One party will make a promise and the other party will again, in consideration, the party will make a promise. So that is said as an agreement. Next we can see about the promise. When a person to whom the proposal is made signifies his assent thereto, a proposal is said to be accepted. A proposal when accepted becomes a promise. So here promise is the one where the proposal when accepted becomes a promise. So here there are two parties. One party will be making a proposal. So there should be other party who should get it accepted. So both the proposal, when the proposal is accepted, it becomes as a promise. So these are the essential elements of a valid contract. So there are 9 essential elements in this. So first we can see one by one. So first element is an offer and acceptance. So offer and acceptance is, in the contract there should be at least two parties. So here one party will make an offer and the other party will get it accepted. So let us see what are the elements included under the offer and acceptance. So first one is same thing in the same sense. So if there are both parties, means both the parties should understand the subject matter in the same thing and in the same sense. Terms of offer must be defined. Suppose if you are making an offer, if A is making an offer car to sell a car to B, means the A should say which car and how many amount, everything should be well decided. Terms of offer must be defined. Next one is acceptance of offer must be absolute and unconditional, and acceptance should be according to the mode prescribed and must be communicated to the offerer. So you have to see the main point here, mode prescribed, so and must be communicated to the offerer. So both the parties, what is the subject matter, everything should be communicated, then only the offer and acceptance will become as a legal contract. Let us see with a better example. A owing two cars X and Y. A wishes to sell the car X to B, but B assumes that he is selling the car Y. Hence there is no contract because no consensus add item. Consensus add item meaning is same thing in the same sense. So here are both the parties X and Y. Here the X wishes to sell the car and Y is going to accept it. We can imagine X is having many number of cars. He may be having one car, two car or three cars. But the Y is assuming that he is going to sell the red color car. So while making the contract, both the parties should be definite which car he is going to sell. He must communicate it to the offerer. Then only the offer and acceptance takes place here. Next. And second is intention to create a legal relationship. So while making a contract, our main intention is to create a legal relationship. It should not be a social obligation. Social obligation in the sense, just we are making a contract with our family members. For example, if a husband promises wife to take her to the hotel, so this will not come under a contract because the husband and wife is making a social obligation. So here the contract means everything should be considered as a legal relationship. If the brothers and sisters or a friends, suppose we can assume if both the friends are discussing and they are just going to a cinema theater, that and all we cannot make it as a contract. So here contract should make as a legal relationship. Agreements of a social or domestic nature do not have any legal relationship, hence they are not contracts. So if both the parties are not having any legal relationship, we are not considering it as a contract. Example, we can see with an example. A husband agreed to pay rupees 10,000 to his wife every month when he was in abroad. But later they were separated and the husband failed to pay the amount. The wife sued for allowance, but she could not get because it's just a social agreement and not a legal agreement. So as said earlier, here both the husband and wife is making a contract. So if the husband and wife is making a contract, it just comes under the social relationship and it is not a legal relationship. So here our contract should maintain a legal relationship element. Next one. Third element we can see is lawful consideration. So here main thing is consideration. So what is meant by consideration? both the parties should get something in return. So if there are two parties in the contract, both the parties should get something in return. Both the parties should be benefited. So that is the main element of contract, lawful consideration. So consideration is nothing, something in return. It is an advantage or benefit moving from one party to another. For example, we can assume the above example itself. If the A and B is going to, if A is going to sell a car and B is going to get a car for rupees 1 lakh, here what is the return is, A is going to sell a car, B is going to have a car, and A is going to in return have an amount. So both the parties are benefited. So here the consideration element takes place. It need not be in cash or kind. It may be an act or promise to do or not to do something, and the consideration may be past, present or future, but should be real and lawful. So here the time bound we can see is the consideration may be past, or it may take at a present, or it may be going to take at a future. The time bound can be anything, but it should fulfill the consideration. That is, it should be the element should be real and lawful. And next element is fourth element is capacity of a parties. So in the fourth element we are going to see if the parties are making a contract, what are their capacities. So who and all legally eligible for a contract. Let us see. That is, a party should attain the age of majority. So they should have attained the age of majority. The minor cannot take place the contract. So only the major person can take a contract, and they should be of sound mind. Sound mind in the sense they should not be a lunatic, idiot or a drunkard person. So while making the contract, their mind should be of in sound nature, that should be in clear nature. It is not disqualified from contracting by any law to which it is subject to, that is, it should fulfill all the elements of the contract. Next, if a party to a contract suffers from any of the flaws like minority. So minorities, he should attain the age of major, he should not be a minor person, and idiocy, lunacy, drunkenness, the contract is enforceable except in some cases. So the party should not be a drunkard. For example, if the party is drunkard and if both the parties are making the contract, or either one of the party is drunkard and if it is making the contract, it will not come under the essential elements of a contract. And the party should not be a minor, and they should be of sound mind. They should not like idiot, or they should not be like lunacy, etc. Next we can say about the fifth element, that is free consent. Both the parties should undertake the contract at the same time and in the same sense. So if both the parties are making the contract, they should assume the contract in the same sense. If A party is saying in the different sense and the B is assuming in some other sense, the contract will not take place. The consent of the parties should not be obtained by misrepresentation, fraud, undue influence, mistake or coercion. So when both the parties are making the contract should not take place by misrepresentation. Misrepresentation is assuming something as wrong. So if A party is saying something and B is interpreting in some other sense, it is known as misrepresentation. Or we should not make a false contract. Next one is fraud. We should not do any fraudulent activity and make a contract. If you are doing any fraudulent activity and making a contract, the contract will not come under the essential elements of the contract. Next one is undue influence. So we should not influence the person, we should not compel the person, or we should not force the person to make the contract. For example, if you are not doing this contract, I will do a physical injury to you, or otherwise I will kill you. Like this, we should not make a person, or we should not force a person, or we should not compel the person in any other sense to make the contract. So these are the elements of the contract in the free consent. So free consent here includes misrepresentation. We should not misrepresent the subject matter of the contract, and we should not indulge in any fraudulent activities, and we should not do any undue influence and a mistake, or by mistake also we cannot go undertake a contract, or by coercion, that is, we should not force the person to make a contract. So if any of these flaws take place, then the contract will become will not valid. And next one is sixth element is lawful object. So whenever we are making a contract, the contract must not be illegal. So illegal is that all the legal activities only we should make a contract. We should not go in the illegal activities and also the immoral activities. And there are some policies prescribed by the law. So we should fulfill all those things. If you are going against the law or opposed to public policy, it will not come under the contract. And next, seventh element is it should not expressly declared void. That is, certain agreements have been expressly declared illegal or void by the law. For example, if you are making a contract with our enemy country, allied country, so it should not come under the contract. So we should not make a contract. Whatever the law is prescribed, that elements only we should fulfill. If you are going beyond that, the agreement will become as a illegal or void. In such cases, even if agreement possesses all the elements of a valid agreement, agreement will not be enforceable at law. So even though if it possesses all those elements of the possible contract, it will not come under the essential elements of the contract, because if you are going to make it an illegal agreement. Next one is 8th element, certainty and possibility of performance. So whatever contract we are making, it should be certain and not vague or indefinite. Vague in the sense, every contract we are making should be in the clear sense and it should be definite. So whatever we are making the contract, for example, if you are going to sell a oil, means there are different types of oil. So we have to be very clear which oil we are going to sell and how much tons in a units we should be prescribed. So everything should be definite and clear. For example, A agrees to sell B 100 tons of oil. The agreement is void. Why this agreement is void? Because that's just the agreement is they are going to sell 100 tons of oil. They are not going to mention which type of oil. It can be oil has different types, so it can be any type of oil. So here, if you are going to make a contract, everything should be certain and definite, and it should not be vague. It should not be it should be in the clear sense. So there should be possibility of performance. And the next point is, it should be certain, and next thing is possibility of performances. It should be possible for performing the contract. For example, if the magician is saying that he's going to discover something through this through his magic, we will not declare it as a contract, because the magician is not going to get it by any trick. So here the magician is not going to fulfill all the essential elements of the contract. So it should be possible of performance. Whatever contract we are making, the contract should be possible for performance. So the magician is doing something, it will not come under the contract. And the last point is legal formalities. So the contract should fulfill all the legal formalities. Even though we have seen all the above said points, the 9th point is the main thing, that is, the contract may be in oral or in writing. So the contract should not necessarily be in writing. It can be in oral or it can be in written. Law requires particular contract to be in writing. So if it is in writing, then it should fulfill formalities like writing, registration and stamped if necessary. If it is an oral contract, then no other formalities is needed. While if it is in written contract, the contract should be in writing and it should be properly registered and it should be stamped if necessary. So these are all the various essential elements of the contract. So if it should fulfill all the 9 formalities, then only we are going to say it as a essential elements of the contract. So first one is the contract should have offer and acceptance, and next one is the intention is to create a legal relationship, and third one is the lawful consideration, and fourth one is capacity of parties, and fifth one is free consent, and the sixth one is lawful object, and the 7th one is it should not be declared expressly declared void, and 8th one is it should be certain and possible of performance, and 9th one is it should fulfill all the legal formalities like writing, registration and stamped. Okay, thank you.